Everyone, my name is Chris Peterson. I'm a law professor here at the University of Utah, and I'm excited to be a part of the symposium. The next panel that we have coming up is focused not on antitrust, but is focused on the closely adjacent doctrines of consumer protection. I'm just really excited about the professors that we have gathered from around the country to speak to us. They are all, in my view, some of the most interesting consumer law professors in America, and that's how I picked them. But I don't want to spend too much time going into their lengthy accomplishments, which you can all see in their bios through the agenda online in the program. Dr. MaNisha Padi is from the University of California at Berkeley, and also has a PhD in economics and is one of the rising stars in her field. And then also Luke Herrine just finished up a fellowship at Yale and is now at the University of Alabama, and also embarking on an exciting career. Lauren Willis is the Associate Dean for Faculty Life and Research at the Loyola Marymount University in Los Angeles, and is a longtime thoughtful critic of some of the nation's consumer financial services regulations. And Frank Pasquale is from Brooklyn Law School in New York City, and is one of the country's foremost thinkers about big data and privacy. So how we've decided to do it, each of our panelists has some research that they've been working on, a paper they're going to present for about 10 minutes or so, 11 minutes. Some of them have slides, some don't. And then we're going to try to save a few minutes toward the end of the conversation for some public questions. And we're going to be using I'm not sure if everybody that's here heard earlier or whatnot, but we're going to use the Slido public participation apps. Push your question to the particular little thingy here I have, and you can even vote on whose question you think is the most interesting, and then I'll try to pose them to the panel. All right, without further ado, I'm going to turn it over to Dr. Padi. And also, if you could, please thank me and join me in thanking them for flying all the way across the country to talk to us about consumer protection.
Awesome. Thank you, Professor Peterson, for organizing, and thank you all for this amazing conference with these big ideas. I am going to narrow our focus a little bit and ask you to think about something a little specific. And I want to convince you that it's interesting. So I'm going to talk about joint work with Helen Bonga, who is at the Consumer Financial Protection Bureau, and Chen Meng, who is at Keene, all of us economists. And I have to give a disclaimer that this is, Helen is an employee of the CFPB, but this is our own views and our own research, not the views of the Consumer Financial Protection Bureau. And I want to ask you all to think with me for 10 minutes about mortgage servicing. So why do I think mortgage servicing is important and interesting? This is a specific industry. Who are servicers? They are the ones collecting your mortgage payments and making key decisions about what's going to happen during a lifetime of a mortgage. And I think these are maybe a little bit underappreciated, maybe not in this crowd. Some folks are deep into servicing, but those who are not, maybe slightly underappreciated players in the market for that consumers often encounter when they take out a mortgage. So what is the structure that we typically we see as a borrower? I mean, many of us perhaps are on this side of this diagram here. If you're a borrower in the mortgage context, you might get a loan from a lender, and that's your primary point of contact when you're starting the process of paying on a mortgage. But the entity that's collecting your payments, the servicer, is a different one, right? And in the spirit of this conference, the servicer is essentially an assignee of the lender, meaning that you do not choose your servicer. There's no competition here, right? So antitrust remedies may not be able to touch this sector, the servicer who you actually end up working with, because you, the borrower, have no choice over this, over who your servicer is. And then the lender may sell the note on to the owner or the investor. Again, they're typically a different entity from the person or the company that's collecting your payments and processing your payments. So when households fall into financial distress, which happened a lot during the 2008 crisis, but then regularly happens, folks start to fall behind on their payments. Their first point of contact is their servicer, and oftentimes the first time they even realize who their servicer is. And so if we think carefully about who is positioned ideally to intervene in the lives of indebted households, since many of us are heavily indebted, we would think servicers are the answer. They're the first entity that knows that you've missed a payment or that you may not even be able to make that first missed payment. On the other hand, servicers have pretty misaligned incentives. So not only is there no competitive pressure, like I was mentioning, there's no competitive market here, they also have this interesting contractual structure that they have to make advances to the owners and investors of mortgages on behalf of the borrower. So they're actually the ones making payments on your behalf. And if you, the borrower, falls behind, then they're the ones who are out of luck. They still have to make advances on your behalf. And because of that, they have an incentive to want to get a delinquent borrower off their books as quickly as possible. If they think you're out of luck and you're not going to be able to make payments anymore, they want to foreclose on your house and get you off their books. And so this misalignment in incentives has caused lots of problems. It caused a lot of problems in the 2008 crisis. And one potential fix to this misalignment issue is regulation. The CFPB acted in 2013 to bring regulations that required a couple of things, actually many things from servicers that were working on mortgages, on all mortgages basically in the country, except with some small exceptions. And they required two categories of things. One is a set of communication requirements. So servicers were required to talk to borrowers early when they fell behind. They were required to maintain continuous contact and generally offer options. So say, foreclosure is not inevitable if you start to fall behind on your payments with your mortgage. And they also have to wait 120 days before they can file a foreclosure action. So that means 4 months, the borrower has have some time to kind of brainstorm, figure out what they're going to do, and turn the situation around. And so this project is using data, empirical data, to ask the question, does regulating servicers in this way actually impact loan performance? So is it doing what it was intended to do and shifting maybe servicers' behavior and then ultimately the mortgage experience? And then finally, can we use this as a little natural experiment to understand the causal role of foreclosure filing in debtor financial distress? So if we care about distressed debtors and their financial health, is this a policy lever we should be shifting to make a difference in their lives? So I'm gonna put some equations up because there's an econ side to this, and so although I'm at a law school, I always jump at the chance to put any kind of Greek letters on the screen. So just to talk through what our methodology is, we're going to use a pretty traditional natural experiment approach, which is to find a treatment and control group. We're not designing a nice experiment, so we can't randomize who is regulated and who is not regulated. So we're going to try to approximate experiment, a random experiment, by finding a control group and a treatment group amongst our population. And who we use as a control group are loan servicers that are servicing loans either owned or insured by the GSEs, meaning Fannie Mae and Freddie Mac, who had already instituted similar guidelines to this back in 2010. So they've been under conservatorship and they've already been regulated. So we're treating them as if they are not affected by this regulation, and we're going to compare them to our treatment group, which are the non-GSE loans, the private market. And then we're going to make all these arguments that economists try to make to say, well, I think this treatment, right, this imposition of servicing regulations is exogenous, meaning it's quasi-random. Why do we think they're quasi-random? Well, we're going to go back in time. We're going to find loans that were originated between 2000 and 2007, so well before the 2013 regulation, and we're going to follow them over time. And we're going to say, well, these loans have been in the market for so long that they're not anticipating servicing regulation. They're not based on the possibility. They were all originated before the crisis. So at the time, they all thought, the world was going to be a nice, simple place back in the 2000 to 2007 period. And so we follow those loans and we watch what happens to them between 2010 and 2017. And then we try to find a nice, safe sample of 30-year fixed-rate mortgages that are not affected by contemporaneous regulations. we're going to go do two things. We're going to do a difference in difference, but I put this equation up just for my pleasure. But all we're doing is doing this comparison. So pre and post 2013 and GSE versus non-GSE. We're going to take differences between all 4 of those groups. And then we're also going to do an event study which separates that out into a year-by-year effect. What's the difference between GSE and non-GSE loans in each year? Let me show you what we find. So this is the event study. And what this is showing you is the difference between GSE and non-GSE loans in each quarter prior to the treatment period. And these 4 periods that are, these 4 periods that are marked in gray are the treatment period. So January 2013 to January 2014. What we see is that foreclosure filings drop very significantly, right? Right at the time that this rule is introduced, you see a drop in foreclosure filings, and then it continues to drop throughout the treatment period. So this is when the rule was announced, and this was when it was enforced, right, at the end of the period. So we see this drop, and it does go up a little bit, but the overall effect is extremely large. We see, and I'll tell you the numbers in a minute, we see a large drop in these foreclosure filings. That makes sense. We have to wait 4 months now to file. There's all sorts of possibilities on why this could be happening. So we also check whether you're current on payments. And we see almost the exact opposite effect. So we see people jumping up and being current on their loans. They're now able to make a payment, get into a repayment plan, do other things that are able to avoid, they're able to avoid delinquency and being behind on their loans, and they're able to become current again. And so this was a surprise to us. We were expecting a drop in foreclosures, but not that people were able to just recover, right? What's the size of these effects? So this is plotting. We have to do our analysis because it's a very large data set. We split it into samples, and then we're showing you the empirical distribution of the estimated coefficients. So what I'm showing you in the middle of this graph, the mean is the point estimate. So we're seeing this drop is about minus 0.008 in foreclosure rate. That's pretty big because the baseline is only 2.8%. So we're seeing this sort of 28% drop in foreclosure filings. And to contextualize the current, we see this is an increase in being current of about 0.025, which relative to this baseline, which is higher, more loans are current than they are in foreclosure, luckily. So relative to this baseline of 88% current, we see that this is an increase of about 2.8% in loans that are current. To give this a little more context, it's like the foreclosure filing effect. It's almost like every single loan that would have been foreclosed is now moving to current. It's like people are, those who avoid foreclosure are becoming current on their loans. So then we're going to say, hey, this is nice. This is random changes. These are random changes in foreclosure filing, right? Because from the perspective of the borrower, they're not doing anything differently, right? They're going about their business. The servicer is deciding not to file a foreclosure action. So that's great. This is a servicer-driven shift in foreclosure, as opposed to a borrower-driven shift, meaning that their payment behavior is very much the same. And we have some evidence of that as well. So if that's the case, this random variation in filing can be an instrument, we call an IV, instrumental variable, that will shift foreclosure, and therefore we can allow us to assess what's the effect of foreclosure filing causally on outcomes for borrowers. And so we do this convoluted approach. This is a nonlinear specification, a duration model, and we do this to precisely predict the probability of foreclosure as a result of just this change in the regulation. So what role does this regulation have in shifting foreclosure? And then we use this as an instrument, and we think this is a good instrument because it's not related to borrower level outcomes or other things that would shift indicators of financial distress. I can show you more graphs that I think kind of show that, but basically this is the instrument that we're using. Predicted foreclosure as a result of this regulatory change. So now our prediction of foreclosure is coming just from whether you were pre or post 2013 and whether or not you were non-GSE or GSE. And so just based on that variation, we can predict your foreclosure experience pretty well. It's positively correlated with actual foreclosure, so that's good. So we're going to say that this is a good instrument. We think it has relevance. And I have other reason to believe that it is exogenous. I can show you, in a Q&A if that's of interest to people, meaning that it's not influencing our outcomes in any way except through foreclosure. So what do we find? So we find a couple of interesting things, I would say. In one direction, we find no significant effect of foreclosure filing on credit scores. What is this? This is the graph showing that. There's a positive point estimate, but the confidence interval crosses 0. So that means there's no effect. I would think about it as approximately 0 effect. And that surprised us a little bit. We were saying, well, foreclosure filing is supposed to be bad for consumers. Well, it turns out that credit scores are way smarter than us. They already know that you're in financial distress by the point at which you experience foreclosure filing. So this filing point at which you're just notified about a potential foreclosure is not a key point from a real standpoint, right? It's not really affecting your credit access. What it is affecting is your spending. So what we see here is a pretty significant drop in your propensity to buy a car. Once you receive a foreclosure filing, you say, this is not the time to spend money. I'm going to be a little more careful. I'm not going to buy a car. I'm not going to pay off my credit card arrears. And so what we're seeing is essentially a spending contraction as a result of foreclosure filing. So I'm going to sum up really briefly. So what do we find? Well, we find that implementing communication requirements and implementing this delay of 120 days in foreclosure filing actually improves loan performance very significantly, more so than we thought. And we do some work in the paper that shows that we think it's really the communication requirements that are driving some of these effects. We use heterogeneity and timelines across states, and we show that we think it's really about early intervention. That's why people become current. They're on the phone with their servicer, actually finding out what the options are for them. And then we see this follow-on credit effect that we think really shifts spending. So two, I think, takeaways that may be of interest to a competition law group as well, an antitrust law group as well, is one, that there are interventions we can make in markets where there's no competitive pressure that still aligns their interests with consumers. And in this case, communication is one of those, right? So when you're talking about the experience of a debt, one of the best ways you can align incentives is to have the borrower and the debt collector in communication with each other in a productive way. And another takeaway from what we're doing is that servicing regulations, such as the one we saw in the COVID times, right, a pause on foreclosures and a forbearance on mortgage payments, acts as a stimulus or acts equivalent to a cash benefit because you're avoiding the foreclosure filing. People have more money now. They feel, whether or not it's true, they feel that they have the ability to spend. And we estimate that amount to be on the average $1,700 just on the 2 or 3 credit lines we look at here. So we think there's positive effects in that sense and cautionary effects as well. So I'll stop here. Thank you so much.
Hi, can you hear me? Okay, great. Okay, so I'm talking about a totally different subject. I think we're all talking about totally different subjects. But it is a subject that was already touched on, which is Section 5 of the Federal Trade Commission Act, and particularly the unfair practices prong of that, which, as we heard this morning, is something that the Federal Trade Commission is considering expanding in addition to the Unfair Methods of Competition Authority. And it's also something that's being used more aggressively at the Consumer Financial Protection Bureau and at the Department of Agriculture as well. And so what I want to do is, what I think this is a sort of substantial break in how the sort of underused provision has been used for the past 40 years or so. I want to explain why I think it's a substantial break and what I think this implies about the meaning of the clause and how we think about consumer protection authorities generally. And I'd be happy to talk in Q&A about how I think it relates to unfair methods, but let's not do that for now. So first, a little bit of background on the clause. So as I guess most folks here know, and as indeed Chair Khan reviewed this morning, the Federal Trade Commission Act was given Unfair Methods of Competition Authority in 1914 when it was created. The meaning of the Unfair Methods Clause was broadly contested, but one thing that the FTC started doing immediately that actually some of the creators of the FTC didn't think it ought to start doing is police bad behavior toward consumers. So consumer fraud, but also what the commission thought was coercive behaviors such as lotteries directed at children and so But what happened is in the as maybe you also know, the courts were often very antagonistic to the Federal Trade Commission in the 1920s. And one of the ways they were antagonistic was they said that if the Federal Trade Commission wanted to enforce, wanted to call something an unfair method of competition that harmed consumers, they had to prove harm to competitors as well. And this was called the Rotterdam decision. And as you can imagine, if it's a monopolistic market, you can't really show harm to competitors. If every competitor in the market is doing the same thing, you can't show harm to competitors. And it's also really hard to show that if you're gaining consumers via fraud, that it's hard to show the magnitude of harm to a competitor, right? That the shift in demand is caused by that. So that was a problem. And that was a problem that the Federal Trade Commission convinced the Congress to fix by creating the Unfair Deceptive Acts and Practices Authority, which explicitly was supposed to be a way of saying to the Consumer Protection, the FTC, keep doing what you're doing. Don't worry about competitive harms. That's the official story. I actually have some reason to question this official story, which we can talk about in the Q&A if you want to know, but that's certainly all over the legislative record. That's what they say they're doing. Now, where does Unfair Deceptive Acts and Practices Authority come from? This may be of interest. I think maybe the phrase actually comes from a modification of the Packers and Stockyards Act, which bans unfair, unjustly discriminatory or deceptive practice or device, and which is worth noting because it indicates a focus on power, and power not necessarily exclusively toward consumers, but within different agents within a market, which might include consumers. All right. So the UDAP authority is created, and it has uneven enforcement in these early years. But the modern, I'll skip a little bit of the history. The modern version of the Unfairness Authority grows out of a particular controversy in the late 1970s, in which the Federal Trade Commission had expanded, under the influence of the Naderite consumer movement, had expanded its consumer protection focus, including with unfair practices, but also deceptiveness and just generally more rulemaking and so on. And this came to a head in the late 1970s when the Federal Trade Commission proposed to regulate children's advertising, and there was a huge business backlash under this was so-called KidVid. Again, I'm happy to get in detail on that narrative and why I think the standard narrative of that is wrong. But the upshot for our purposes is that out of this kerfuffle, the FTC defends itself. The Congress is at this point threatening to remove Unfairness Authority, and indeed removes Unfairness Authority with respect to children's advertising, and is also defunding the FTC. This is probably familiar to some people. So what the FTC does, among other things, is they say, Congress asks them, look, tell us what unfairness means, and the FTC successfully defends itself by defining unfairness in the modern way, and it creates this what's called this three-part test, or the substantial injury test, which says a practice is unfair if it causes substantial injury, the injury is not reasonably avoidable, and it's not outweighed by countervailing benefits to consumers or competition. So that's actually still quite a broad authority, I think. But what also happens is conservative forces, or what I would call neoliberal forces, take over the FTC. Again, this is going to be familiar from antitrust at the same time, and they interpret this three-part test as a consumer welfare or a consumer sovereignty standard. So basically what the Unfairness Authority is supposed to do is narrowly, first of all, it should be narrow. It should only basically aid occasionally in policing around things that are not quite deceptive but close to deceptive, like inadequate disclosures, or outright coercive bad behavior, like not enforcing the clause of your contract. And the overall purpose of the authority is understood to basically be make markets work better, make consumers better able to choose, have more disclosures, remove these outright barriers, but don't think too deeply about policy or morality of different practices. Okay, so skip to where we are now. So I think there's now this nascent revitalization of this authority in a few departments. So the Federal Trade Commission is doing this commercial surveillance rulemaking, which is under the Magnuson-Moss rule, which came out of the 1970s, and includes, for instance, algorithmic discrimination, focusing on children's mental health, data security. This is not about deceptiveness. This is not about increasing ability to choose. This is about reorganizing rights and benefits and burdens within a market. And it can only be done, I think, under its existing unfairness authority. It doesn't have other authorities to do it. At the Consumer Financial Protection Bureau, you have the recent use of unfairness authority in supervision to target disparate impact discrimination beyond any particular domain, right? Beyond Equal Credit Opportunity Act, right? Just broadly on data practices, the CFPB has started to monitor, and indeed it's being sued for doing so. You heard Chair Khan say the FTC is using unfairness authority to actually protect workers. The Department of Agriculture is using the Packers and Stockyards Act, which is a distinct but related authority, to police terms of contract between poultry companies and growers. And there's been other suggestions in the literature. This is a growing area. So I think this suggests a reinterpretation of what the unfairness authority is. And the other thing I should say is, on a slightly pushing back the timeline a little bit, the Consumer Financial Protection Bureau was given something called the abusive authority to basically supplement the perceived inadequacies of unfairness authority to say that we need to expand this. So this is all a way of saying we're thinking more broadly about what the unfairness authority is. So what does that mean? So what I think it means is the following. On the one hand, more sector-wide regulation, not just case-by-case adjudication, and not just deception or outright coercive conduct. And there's a different sense of what it means to make markets work better. The focus is on substantive fairness, something like not trying to make a market a more perfect form of competition, but rather taking social circumstances and power seriously. The goal, I would say, is to prevent business from taking advantage of their power over consumers and to solve collective action problems that markets cannot solve through competition. So I think this allows us to reinterpret the three steps differently. So a substantial injury is one thing, but traditionally, the not reasonably avoidable prong has been understood as basically, look, something is not reasonably avoidable if somebody is irrational, if a consumer is irrational, there's a distinct market failure, there's an information failure. But I think this new interpretation suggests that there are irreducibly social aspects of the market, and you have to account for the socialization and preference formation. And so part of the goal is to think about, people can't choose their own privacy. People can't choose how they're going to be treated, whether they're going to be discriminated against or not, and that's sort of independent of whether they have free choice on the market or not. What's my time?
You've got about a minute.
Okay. Okay. And the other shift, I think, is to thinking about, so that's the reasonable avoidability prong, and then there's the countervailing benefits prong, which has traditionally been understood as basically a cost-benefit analysis. But I think the modern understanding is understanding it as cost and benefits should be scoped according to the interest that's being protected. So if you're protecting somebody's privacy, you can think about cost as a countervailing analysis, but you have to think about it in terms of the overall effect of privacy. And for instance, if you're focusing on how a practice disproportionately harms a certain group, you should discount benefits to people who are not members of that group, which is a different way of understanding cost-benefit analysis. So anyway, much more to say, but I think this is an emerging re-understanding of the unfair practices authority, which can supplement the emerging new understanding of the unfair methods authority.
Yeah. Got slides?
Trying to. They're up. Maybe I'm going to have to get somebody to help me.
Well, I'll go ahead and start while they're putting up the slides. Thank you to the Utah Law Review for hosting the symposium and for the organizers for putting together such a diverse group. At least for me, I don't usually interact as much with antitrust economists, usually only with behavioral economists. So I'm going to talk today about lessons from consumer law for consumer-facing remedies in competition. And what do I mean by consumer-facing remedies? Well, I'm not talking about structural remedies. I'm not talking about firm-to-firm behavioral remedies. I'm talking about things that attempt to drive consumer shopping behavior so that consumers can drive competition. So things like providing information to consumers, things like that can be a little stronger than that, like requiring firms to reduce switching costs or prohibiting firms from self-preferencing in setting things like defaults. The punchline is that generally these things haven't worked, and it should come as no surprise, given our experience in consumer law. And so these remedies that have been tried in the EU and the UK and some in some countries in South America primarily, but are thought about here as well, should not be pursued, and we should pursue other alternatives. And to make them work would require them to be incredibly intrusive, actually, into firm implementation of the remedies, such that structural remedies don't sound so bad after all. So why do these remedies fail? Well, the reasons we would expect them to, right? Consumers respond in unexpected and diverse ways to these remedies, and firms, which this should be completely expected, not unexpected, outmaneuver remedies. So, for example, there have been these requirements that are intended to reduce switching costs, so decreasing the duration or the amount of termination fees, or increasing data portability. But those have not worked very well because you've got to also change the consumer perception about what the costs are going to be of switching. The consumer fears, many of which are quite founded, about data privacy. You have some new third-party intermediary come up and say, oh, well, we'd like to take your open banking data and help you shop better. Gee, I got a text like that asking me to send money to Nigeria too, but I'm not going to do that either. And there's also the issue of, so what if you reduce the barriers to leaving one firm if you can't figure out what the actual costs and benefits are of the product you're in or of the competitors' products, then you're not going to go there. And even then, you have to be sure that benefits that you anticipate will be durable, that the company you go to cannot then reduce benefits, increase prices. So the remedies that people have imposed thus far, regulators have imposed thus far, have been rather naive. So another example mentioned last night is these self-preferencing defaults, prohibiting those. Obviously, you'd also have to prohibit requiring consumers to pay various costs for declining the firm preferenced position. The experience with this in consumer law is that when we have imposed default positions, they have not turned out to be sticky when they're imposed by regulators. Firms can just overwhelm consumers with options, as they did when the EU required Google to give consumers options Microsoft gave consumers options in which browser they would choose. They can confuse consumers about what position they're even in, trick them into thinking there are costs, and my personal favorite, the annoyance costs. So here's an example where it's difficult to know what position you're in. So you say that you've got to, to change your privacy options, you've got to move this little toggle button. The default here was intended to set a pro-privacy default. But when you read this, let apps use your ID to make ads more interesting to you based on your app usage. Does turning it to the right turn it off? Yeah. Or does turning it to the left keep it off or turn it off? Turning this off will, by the way, reset your ID, which sounds like something you really probably don't want to do, right? Or this very blunt messaging in the overdraft area, warning you that terrible things could happen if you don't opt out of this government-mandated default position of not having overdraft on your checking account. So this one is my favorite. You try to go into online banking, and you get this pop-up window asking you to opt out of the default. And every time you go into online banking, until you say yes, this pop-up window will come up again and again. So difficult to catch those, but those are real costs to consumers. So how is this achieved? Well, these days, using sort of the digital abilities, firms can actually hone these various techniques to a greater degree than I just showed, of course, to optimize their effectiveness for different consumers. And this is even like a very old graphic of what this is. It's now at machine learning speed, right? So how might we improve consumer-facing remedies? Well, one thing that's been proposed is, well, let's start surveying consumers so we understand them better. But consumers have very little insight into what drove a decision that they made. And regulators are not ordinary humans. Faculty members are not ordinary humans anymore in many ways, that we just don't see things the same way. Full employment for behavioral economists is another suggestion, but they also do not predict very well exactly what consumers will do. Test remedies in the lab, but the whole issue here is about context. You can require a firm to do something in this little screen, but the context is what pushes the consumer in one direction or another. So then people say, well, let's do some field trials. Look, firms are not stupid, right? They're going to wait till after the field trial to outmaneuver remedies. And the idea that we're going to then be able to, well, we'll just keep changing the remedy to catch up with the maneuvering, firms can change tactics more quickly than regulators can revise. So what does this mean? Well, maybe structural remedies aren't so bad. That consumer-facing remedies are not going to be able to achieve some of the things they can. Data privacy also is key, not only to protect consumers, but to preserve competition because of the use of data to achieve much of this manipulation. And then I have a proposal for a different form of regulation, which is results-based competition remedies. So what do I mean? Well, this has been adopted this past summer in the UK for consumer financial transactions, and a bit earlier, a narrower version of this was adopted in Australia. I helped both of the regulators in both countries do this for consumer financial products. So the idea is to basically take a page from the regulation of harmful emissions from factories. That we don't say how the factory has to produce its good. We say, what comes out of your smokestack can contain no more than X amount of this pollutant. Get there however you want. Change your fuel inputs, change your processes, change your scrubbers, what have you. So the idea translated to this context for consumer-facing competition remedies would be to set measurable outcomes that would demonstrate a reduction in barriers to competition, give firms responsibility and flexibility to meet those, and then require at least dominant firms to demonstrate achievement of those. So things like, instead of saying, well, get rid of this termination fee or get rid of, require this data portability, instead just demonstrate that, in fact, your consumers are not abandoning their cancellation or termination attempts and that they're spending no more time leaving you than they did signing up for things in the first place. Surveys of your customers to show that they don't believe that this would be terribly difficult. Make sure that consumers can understand things to shop. Well, surveys to show your customers know the prices that they're actually paying and the limitations on benefits they're receiving. And you might also check firm records to see whether that customers understand things so poorly that they're selecting dominated options. Now, what can firms do to reach these outcomes? Well, they can, better than regulators do, identify the frictions that prevent consumers from switching. They can make prices and products simpler so that consumers can, in fact, understand them and therefore shop. They can eliminate dominated offerings. They can use marketing strategies to communicate more effectively. And then, of course, they could use the same tools that they use for manipulation purposes to make these things work. And, of course, we'd have to require some demonstration that the outcomes were being reached. There's proof of concept in this in that one firm in a deception case did survey its own customers, did random sample surveys to demonstrate that their customers were actually not deceived by some marketing that the FTC had charged the firm with deception about. And then there has to be, obviously, an incentive, some kind of fines, or maybe if you can't demonstrate that your customers, take no more time to terminate their relationship with you than they did to sign up, then structural remedies might be imposed. And so basically, this is designed to deal directly with the two issues that are problematic for consumer-facing competition remedies. Thanks.
Sorry. All right, I will set my timer to give myself exactly 10 minutes and 20 seconds and try to get you to lunch on time. So this is a project that I've been working on called Consumer Reputation in an Era of AI, Filling the HIPAA Gap. And essentially, where we start with is big data's promise and peril for evaluating persons. There's been a lot of discussion about the new advance notice of proposed rulemaking of the FTC. I think it's a very important initiative. Really, it's terrific to see the level of intellectual initiative behind this. They recognize, of course, on the left side that there is some promise of big data in terms of how it is used to evaluate persons and to create reputations. But we also have to realize that big data, and it's often cheap data, tends to concern inaccuracies. Some data is inappropriate, and it may lead to new forms of discrimination. So therefore, these new rules to govern commercial surveillance have to think about how we protect consumers' reputations from those sorts of outcomes. I think Danielle Citron's recent brilliant book, The Fight for Privacy, talks a lot about these issues in terms of black box AI becoming more common and decontextualized data turning discrediting in numerous contexts. And what I want to take you on over the next, say, 6 slides or so is a bit of a journey about where could AI-driven consumer reputation creation go without regulation. Well, one study that recently came out, or that came out a few years ago, was on using people's mouse twitches or the way microtremors in the hand to predict Parkinson's. Okay, so we had an example of people, and it wasn't the only predictor, it was only part of a larger model. But the thought was that you could have massive amounts of data from a search engine, look at, say, the people that search for Parkinson's, and then look at their records of how their mouse was moving 6 months before. And it turned out there were predictive microtremors there. This shouldn't have surprised anyone, because if we look back to the Rockefeller Committee's inquiry into what data brokers have and what type of inferences they make, there was even then revelations about data brokers being able to infer, say, people that had allergies, people that had asthma, people who had HIV positive diagnoses, many different types of conditions. And I think this is really concerning because a lot of people may assume that that type of information would be covered by HIPAA, but it's not. And that's the type of gap that I'm going to try to encourage us to fill with, say, this rulemaking or other interventions, because there is that massive gap out there in terms of people's privacy. Another report that came out several years ago was from Privacy International, where they found, for example, that when some lenders in India see political activity on someone's Twitter account, they'll consider repayment more difficult and not lend to that person. Another firm analyzed how individuals filled out a form and could make inferences in that way. A Wall Street Journal article talked about clinical trial recruitment for an anti-obesity drug based in part on big data, where if they knew about, say, individuals who were more likely to watch TV, do web shoppings, and have a minivan, they were more likely to be obese than those who, say, had pets, took vacations, and were higher income. Okay? And this, I think, are the type of inferences, totally unexpected and something that you really cannot guard against, that are going to become increasingly possible and prevalent. Moreover, we have seen, for example, a startup selling a service that predicted terrorist proclivities based on facial analysis. Other companies were developing facial recognition software only to catch known criminals, but also wanted to help governments predict other possible criminals. That led to my intervention in the Association of Computing Machinery Journal to talk about when machine learning is facially invalid. I wanted to be sure to warn those in technical fields that maybe this is something they should not be working on. But we still see the rise of affective computing, the efforts to, say, derive inferences about someone's emotional state or how they're feeling or what they might do based on their face. And sometimes this, of course, is totally innocent. You know, this example of, say, finding surprise on someone's face out of, say, 8 potential emotions. But we also see increasing reference to the failures of emotion recognition in the work of psychologists like Lisa Feldman Barrett and others. And this has led to a lot of concerns about the potential stakes of these types of inferences. So, for example, imagine a chain of stores that has to decide, for example, whether an individual at one of its checkout kiosks, automated checkout kiosks, is either aggravated or enraged or suspicious. I predict that within the next 5 to 10 years, you will see subroutines of affective computing that will do exactly this type of sorting, trying to sort out people. And of course, this also might potentially have inferences with respect to mental illness or other things that touch upon health-inflected or health inferential data. There's also major concerns about bias. If we look at the work of Lauren Rue, she has found, quote, black men's facial expressions are scored with emotions associated with threatening behaviors more often than white men, even when they are smiling. This is from her article, Racial Influence on Automated Perceptions of Emotions, 2018. Again, very concerning. There's also concern, say, about proposed Zoom engagement scores. Imagine if every time you're on the Zoom, there's some computer algorithm parsing whether you're actually listening or just checking out Twitter, checking out some other thing. I think and also this type of technology had been introduced in China via the firms Hikvision and Hanwang with respect to something called Class Care, which could analyze students' faces either once per minute or once per hour and report back scores for engagement about the student, which could be reported to the student's parents, and then about the classroom and about the teacher's abilities. And I think that we do have a very effective regulatory proposal with respect to some of this surveillance, in California's Workplace Technology Accountability Act. I think that act has many potential recommendations that should guide larger discussions of regulation of commercial surveillance. And these are not just sci-fi worries, right? I mean, I've given you some sense of like where we could be going, but I will note that Sandra Wachter, a really leading analyst of automated decision-making and predictions about individuals, has written that groups like dog owners, sad teens, video gamers, gamblers, or the poor are routinely used to allocate resources, and these algorithmic groups feed into important automated decisions, such as loan or job applications that significantly impact people's lives. So I think that's another issue where I would be very concerned about. We have heard earlier from Luke about unfairness authority regarding commercial surveillance and consumer reputation creation, or at least I'm applying it here. I do think that many of the things that I've discussed, as mentioned in Wachter or on the horizon, would indeed cause or risk injuries that are substantial without offsetting benefits and ones that consumers cannot reasonably avoid. So many forms of reputation creation via commercial surveillance should be under some form of rule to make sure that at least there are some basic rules of the road going forward. What can we do? Well, I want to offer first 5 broad lessons from credit scoring, and then some specific things with respect to either health or biometric data that may be entering into these types of decisions, attributions, reputation creation. One is that, I think that we learn from credit scoring that not all data is relevant or fair to include. If you have a bankruptcy that's over 10 years old, that's not included. The CARES Act included certain types of data that shouldn't be in credit reports. There's all sorts of things that you could say that really should not be in those credit scoring algorithms. The second is that the score deserve data transparency. If we look at the ideas behind both the Fair Credit Reporting Act and the adverse action notices that are behind the Equal Credit Opportunity Act, those both are emphasizing the need for some forms of transparency for those that are scored. But data subjects can't manage the scoring deluge on their own. We're well past the time when we should try to rely on, tell people, look, here's notice, here's consent, here's an understanding of what type they're doing to you. Just try to navigate the landscape on your own, because much of this data is collected against people's will. So they just can't make that type of decision. Structural dynamics are important, and runaway data that escapes one context and goes into another, it can be stopped. There are ways of trying to stop that type of spread of data. Now, one direct application of these principles is, to me, filling the HIPAA gap, right? While HIPAA creates strong confidentiality duties with respect to covered entities, which are largely doctors, hospitals, insurers, et cetera, there are many firms that now collect, create, and share health-inflected or health-predictive information that are not covered by HIPAA. This was something covered in the FTC HHS Roundtable of 2010, which discussed some of the division of authority over, say, personal health records for the FTC and electronic health records for the HHS in the type of data collection and making sure that there were some basic privacy rules of the road there. And also in Nicholas Terry's article, Big Data Proxies. So to fill this HIPAA gap, here are 6 rules. Part 1 is that large data controllers which maintain health information shouldn't be permitted to use that information or share it with others without specific consent from the data subject or governmental authorization. It's sweeping, it's ambitious, but I think it's something worth thinking about and at least trying to work from as we think about these rules. Second, that there should be at least some auditing mechanism so that any entity with records about 100,000 or more persons should publicly disclose from whom it gathers data and with whom it shares the data. This is something I brought up to a federal trade commissioner about 10 years ago. They were interested in it, but I think it's something that we really need to drill down on to solve the black box problem. And the data subject should be specifically empowered to choose to opt in or out of marketing based on health inferences. I'd further state that when there's risk of health data or other sensitive data being used specifically for stigmatizing purposes, governments may be justified in banning it. And if the roles of doctors, administrators, and AI experts are to blur, then the ethical and fiduciary standards of medical professionals should govern many of these roles. I'll leave number 6 for you because I'm almost out of time, but I will say that if you're interested in any of these points that I've made, the 2 books, New Laws of Robotic and Black Box Society, get into this, and moreover, there's some other articles as well. So, thank you.
So I could imagine talking about each of the papers that you're working on for hours. But for a symposium like this, we have to move things along because there's so many people with interesting ideas. Several questions came in on Slido, and one of them was originally directed for Professor Herrine, but I think it also speaks to Professor Pasquale's paper as well. The question is the trend of a socioeconomically informed view of the not reasonably avoidable prong in the FTC, the Federal Trade Commission Act and the Consumer Financial Protection Act, the FTC's authorizing statute and the CFPB's authorizing statute, is that emerging as a response to the fiction of a meeting of the minds in modern digital contracting? You think of the click boxes, or even when you're just reading through a transaction, or now for you, Professor Pasquale, when you're going up apparently to check something out at the grocery, you're consenting to having potentially a effective test with a camera screen on you. Is the willingness of the you can tell it's my question, can't you? I typed it in on Slido, but it's mine. I'm outing myself. Is the willingness of the federal agencies to start to think about what's reasonably avoidable and not, is it a response to the way that we're forming our contracts?
So I would say in part, I mean, I think so Frank talked about the notice and consent regime as being sort of the dominant paradigm even, I don't know, 5 years ago. I mean, and so I think it's not just in the domain of contracts, but more generally with respect to regulating consumer markets, there was this notion that all you had to do was to like tell people what was happening and they could make a decision. But for some of the reasons that Lauren very ably points out and has been pointing out for a long time, not always being listened to, we increasingly know that just people cannot possibly make decisions about all the things that are happening to them. And I think the digital world and like all this data analysis has made that increasingly obvious in a way that it hadn't, for whatever reason, hadn't been before. I think maybe because notice and consent was tried. But I think the other thing that's happened recently is that, you know, a lot of the shifts that this conference indicates, this focus on how power works, both in terms of like, you know, post Piketty focusing on inequality, which is, again, it's like an inherently relational phenomenon. It's not about really individual choice. And more broadly, like how power structures who gets what in a market is more of a focus of analysis. So when you get people at the FTC or at the CFPB who are informed by that type of analysis, when they come to consumer protection, they're more inclined to say, well, obviously there's not going to be choice about this matter. I don't know if you wanted to.
Well, yeah, I would just add that, you know, I have a 2013 article called Privacy, Antitrust, and Power. And there I particularly emphasize that in monopolistic, quasi-monopolistic areas, the terms of service are essentially a sophisticated way of disguising coercion as consent, right? That's all they are. And that ultimately, the truly valuable way of approaching these things is almost an administrative law approach, where we recognize what I've also called in other work, the functional sovereignty of the large firms online. They're functionally sovereign over parts of our lives. And to realize that, you know, to the extent they change these rules or impose unfair rules, there should be similar types of mechanisms of challenge as we see with respect to the Administrative Procedure Act, Section 706, opening up with respect to challenging government. And there I follow the example of the theory of Professor Elizabeth Anderson, her book Private Government, and others. And I think that we've really reached that point. And that really is the connection between, say, consumer protection and competition here, right? Where there's almost no competition, it's like they're governing the area.
Professor Willis, the FTC and the CFPB are both engaged in rulemaking for junk fees. They could ban the fees. They could require better disclosures. What is the results-based remedy?
The results-based remedy is that consumers know that they're paying the fee, how much it is, and what they're getting in return. So the limitations on the benefits that are claimed. And if you can't demonstrate that your customers know those things, know in fact that this credit insurance isn't going to cover a damn thing, then you can't sell it.
Well, and then, you know, Professor Padi, one of the things I was struck about your paper is when the CFPB's mortgage servicing regulations required communication on the eve of foreclosure, there was this increase in loan performance in your data set, which is really like a interesting contrast to the way that contracts are being formed in, you know, in the way that both Professor Herrine and Professor Pasquale's papers were talking about, where we have these very thinly formed contracts with virtually no meaningful consent, where and a new recognition that we have to have a deeper understanding about what's reasonably avoidable or not. Your paper points out how we do have ways of facilitating reasonable understanding, and it can create more Pareto-efficient outcomes. But the question that somebody posed from the audience was really, I think, a technical one. For Professor Padi, there are pretty large pre-trends in the event study for the foreclosure outcome. Is that because the GSE loans were newly regulated similarly as the non-GSE loans in the few periods prior to the treatment?
Yeah, great question. So we've been recommended that we should detrend, and that's, we can do it. We can show the graphs without the pre-trend. But one of the reasons we wanted to leave that in there was that. So a couple of things. Is it because of the pre-treatment? It could be driven by it, but we can't isolate that. The reason is that the GSEs acquired a bunch of non-GSE loans during the crisis, which caused kind of a contamination between our treatment and control group. And so it's possible that that could be driving some of our effect. We were also concerned or thought a lot about the possibility of stockpiling of foreclosures, meaning that delinquent mortgage borrowers were being punished in advance of rulemaking by kind of aggressive foreclosure action. That then because they were expecting the CFPB to act, and so they were like rushing foreclosures beforehand. And so we wanted to investigate that really carefully and look for possibilities of bunching. And so we did do that analysis. We took a lot of we took a look to see whether we could find similar types of people in the pre-period that would have been foreclosed later, actually being foreclosed earlier, and we didn't find any evidence of that. So that's one of the reasons the graph looks like that. I think is to leave open that possibility and explain a little bit about why we think that might be happening. So what I actually think is happening is trends in the post-financial crisis period. So this was a time, I think, in which the GSEs were tightening their servicing requirements. So the difference between the GSE and the non-GSE groups is that GSEs are year by year during their conservatorship have been expanding their servicer guidelines, and they continue to do that to this day. And so there is a shift in the non-GSE. There's a trend in the GSE world that is kind of secular and unrelated to our regulation.
Well, fascinating stuff. And thank you. I guess we need to break now and give it a little bit of break, and then we're going to reconvene for lunch, which I believe is next door, right? Yeah. So just down the hall and to the right, you'll find lunch and our keynote lunch speaker. But before we all go, would you please join me in thanking our distinguished guests to Salt Lake City for coming and sharing their research with us?
And thank you, Chris.